Hi there. I wanted to give you some updates. In the Petito versus Laundrie lawsuit, we have 3 new court orders that the judge has issued, and there's something very interesting I found out that I think most people are missing. Do I think there might be another lawsuit? Yes, I do, and I'll tell you why. So, stay with me. Please do subscribe, hit the like button, share these videos, and do leave a comment because this video is simply my opinion. And I want to know what your analysis is. So please do leave a comment. And I want to tell you a couple housekeeping matters. Number one, this channel now has the community tab open so I can communicate with you. I can send you comments. And I can probably invite you, because I'm thinking about this, is doing a live stream. But the live stream is only going to be open to those people who subscribe to this channel. So please do subscribe, because I'm looking at my calendar and I'm planning on doing some live streams and I want you to join us. So please do subscribe. Okay, so what is going on in the Petito versus Laundrie lawsuit? We have, just to get you up to speed here, and again, please go look at my prior videos I've done, specifically examining the Petito versus Laundrie lawsuit, so that'll fill you in as to why Gabby's parents are suing Brian's parents for withholding information, not telling them where Gabby was, right? And it's a tragedy. It's a terrible tragedy. Both families lost their children, and both parents, I'm sure, have undergone a tremendous amount of stress. It's a tragedy for everybody involved. Okay, so when Gabby's parents sued Brian's parents for infliction of emotional distress, Brian's parents responded with a motion to dismiss. And they're alleging that they didn't have to talk to Gabby's parents. They're relying on the Constitution, the First Amendment, right to speak or not speak. The Fifth Amendment, the right to remain silent. Right? The Sixth Amendment, the right to retain counsel, because they went out, Brian's parents contacted a lawyer. The lawyer made statements, told the press, told the public that the Laundries were not going to be making any statements on the advice of counsel. So Brian's parents are going to be challenging and trying to get that lawsuit dismissed based on those grounds and other grounds. Okay? So I want to give you an update on these court orders that have been issued and the upcoming dates, and then that interesting thing that I discovered that I'll share with you. So, hi there. I'm Michele Hagan. I'm a legal analyst and a former prosecutor. You may recognize me because I provided a lot of legal analysis on the Elizabeth Holmes case. So, again, this video is simply my opinion. I want to know what your analysis is, what your opinion is, so please do leave a comment and please subscribe because I want you to join these live streams. All right, so let's look at the court orders, and let me give you a little additional background. So one of the things in Gabby's parents' response to Brian's parents' motion to dismiss the lawsuit is that Gabby's parents said one of the things is that they need to fix up their complaint, because Brian's parents are saying you didn't plead it correctly. There's not enough facts in here. You're not telling us which defendant, whether it's Brian's mom or Brian's dad, did X or Y. Okay, I know it gets a little technical, but just stay with me, all right? I'll explain it. All right, so let's go ahead and take a look at these court orders. I'll quickly go through them, and then I want to show you something I found, okay, that I think a lot of people are missing. So this is the first order we're going to look at. This was issued by the court. It says an order granting plaintiffs leave to file an amended complaint. So that is the judge issuing an order allowing Gabby's parents, the plaintiffs, to amend their complaint because of some deficiency. And so what is it that they're going to be fixing here? Before the court without a hearing, so the judge didn't have a hearing. We're going to have a hearing probably later for the motion to dismiss, the dismissal hearing. That'll probably be set, my guess would be sometime mid to late May, because they have 20 days. If we read this order, before the court without hearing is defendant's motion to dismiss, which they filed on March 30th. That's Brian's parents' motion they filed to dismiss Gabby's parents' lawsuit. The plaintiff response was filed on April 11th, and you can look at my prior video on that. Plaintiff in response conceded that they needed to separate out the individual complaint claims. So Brian's parents alleged in their motion to dismiss that the lawsuit was deficient because they didn't separate out which defendant did what, right? And the reason they have to do that is you have to give defendants notice of what they're being accused of, right? Was it Brian's parents, Roberta Laundrie, who blocked Nichole Schmidt, Gabby's mom, from getting any information from Facebook or being able to be on Facebook or to respond to any of her cell phone text messages or anything? Or was it Christopher Laundrie who did that? And was it Christopher or Roberta Laundrie who the plaintiffs claim Brian told that he had murdered Gabby? Do you see where I'm getting? They have to specify which one. And since the plaintiffs already said, yeah, we need to fix this, the judge is saying, okay, we don't need to have a hearing. I'm just going to go ahead and issue this written order, which is what we're looking at. So, based on the plaintiff's concession, the court will treat the plaintiff's response as a request to amend the plaintiff's complaint and grant the plaintiff 20 days. So, if I did my math right, I think that's May 3rd is 20 days from the date of this order, which was, I think, the 12th or the 13th of April. So 20 days they have to fix the complaint, to figure out what they're alleging, which defendant did what, okay? And the court also says if plaintiffs do not file an amended complaint, defendants may proceed to address the motion to dismiss. So the defendants can also, they can go ahead and proceed with asking the court to dismiss the lawsuit because it's not sufficiently pled correctly. To be clear, the court in today's order is not passing on the defendant's arguments that this lawsuit should be dismissed with prejudice. So in other words, the court is saying, I'm just looking at whether or not the complaint, the four corners of the complaint are sufficient. That's all we're looking at. I'm not looking at the merits of the case. I'm not looking at anything else. And I'm not ruling on the arguments in the motion to dismiss that the defense has raised. They're not getting there yet. That's the next step. The first step is we got to get the complaint right. The four corners have to be sufficiently pled to give the defendants notice of what they're being accused of who inflicted what emotional distress, allegedly, right? The court's intent is to address the perceived procedural deficiency before addressing the merits of the defendant's motion. All right, so 20 days, so sometime after May 3rd, after they fix the face of the complaint, right, the four corners, they sufficiently plead it, then the court will set a date for the hearing on the dismissal motion. And that will be, there'll be a hearing with all the parties, their counsel, and I'm sure the judge will allow them to make oral arguments, right? But is also going to be relying on what they put in their motion to dismiss, what the Gabby's parents' response to that motion to dismiss was, which they've already said they think it should be dismissed because they don't think the Constitution applies, is what they are alleging, right? Because they're saying that Constitution doesn't apply because the government, state action wasn't involved. It was just one parents asking other parents, where is Gabby? Where's their daughter? That's what the defense is alleging, right? Or I'm sorry, that's what the plaintiffs are claiming the reason to not dismiss, because no state action. And again, if you look at my prior video, that'll fill you in. So the court ordered this on April 13th. So 20 days they have to fix the complaint, the lawsuit, to fix the complaint, what it says, to say which defendant did what, allegedly. Then the court will have a hearing and oral arguments on whether or not to dismiss the lawsuit. That's when the judge will decide whether or not this lawsuit should be dismissed. Does the Constitution apply? Do the other arguments that were presented by Brian's parents apply to dismiss this case? Or does the motion to dismiss get denied and the case proceeds to trial? Okay, I hope everyone's following this. All right, let's look at what else the judge did. So the judge gave us orders issued orders saying, giving us some dates. He set the case for trial. He gave a trial date. And the trial date is August 14th, 2023. He gave a pre-trial conference date, July 7th, 2023. A docket sounding, which is August 4th, 2023. What is all this? This is all over a year away, over more than a year away from now. It's 2023, it's not 2022. So what happens? Assuming the motion to dismiss is not granted, the case survives, proceeds to trial, right? During that period of time, both sides are going to do what's called discovery. They're going to be asking questions, written questions of each other. What did you know? When did you know it? They're going to be asking, did you assist Brian in making arrangements to get out of Florida, to leave the country? What else happened? There are also going to be depositions where the lawyers are going to be able to ask both the plaintiffs and the defendants questions, right? Then there's also going to be requests to produce documents, maybe phone records, to show whether Gabby had sent any texts, whether Brian had sent texts to his parents, what information, because two of the main things that Gabby's parents are alleging is that Brian's parents knew. They were advised by Brian that Brian had murdered Gabby. Secondly, that Brian's parents had made arrangements to get Brian out of the country. That's what they're alleging. All right? Those are two of the things that they're alleging. And again, please look at my Examining the Petito Laundrie Lawsuit, as well as the updated videos I've done since then to fill yourself in. Okay, but what else did we learn about this order? In this order, that the estimated trial length is 3 days. 3 days. That's what the judge is saying how long this trial is going to be. And that's based on the representations that were made in the case management report, which I'll show you in a second, which is what both the plaintiffs and the defendants suggested the case would only be 3-day trial. And that's not very long. 2 to 3 day trial. Okay? So that tells us some things, right? That they don't expect to be calling a whole lot of witnesses, not a whole lot of testimony. It's basically going to be, the plaintiffs are going to, testify. The defendants will testify, as to what. They'll all be subject to cross-examination. They'll pick a jury. They'll start out picking a jury first, which might be a little tricky, right? Because it's a high publicity case. But, the question comes down to, can you as a juror be fair and impartial? And we also learned that the trial is going to be conducted in person. It's not going to be by Zoom. And then the pretrial conference and the docket sounding, they can either appear, the attorneys and the parties can either appear in person or by Zoom. What's docket sounding? Okay, I'm not a Florida lawyer, I'm a California lawyer, but my understanding of docket sounding is a court hearing that takes place approximately 14 days before the trial date, where the parties and the counsel show up and they tell the judge whether they're ready to go to trial. It's basically a status check. Are the witnesses ready? You ready? Everyone ready to go to trial, right? Because they want to keep the case moving forward. Okay, so it was ordered, that the attorneys have to comply with the local rules, standards of professionalism, and the court is telling the parties that they have to adhere to the recent discovery and case management deadlines in the case management order, which I will show you. So this court is putting everyone on notice, putting the parties on notice that we're sticking to the deadlines, right? We're going to be efficient. We're going to move this case. Okay, and then under number 3, each party is limited to 1 expert per specialty. That's interesting, right? 1 expert. So you can't call a bunch of witnesses to talk about, a bunch of therapists or whoever they're going to have testifying. This is an intentional infliction of emotional distress. So they're going to have to the plaintiff will have to put on witnesses, I assume, that are going to testify, experts, therapists, doctors, who will testify as to how this affected, psychologically, what kind of stress, severe stress, by not being told information, being completely blocked out about what happened to their daughter. I mean, it's terrible, terrible tragedy. Okay, but the court is telling both sides here, we're only going to have 1 expert. So if you're going to have someone talk about, some emotional distress syndrome, you get 1 expert. You don't get to bring on 3 experts on that same area. Okay, so that's kind of interesting. Then The court says that they want the attorneys to appear at the pretrial conference unless they have completed a pretrial conference order. And my guess is they're probably going to complete the order, so they won't have an in-person pretrial conference. That's my guess, but we'll see if the court issues that. And they're also saying that the lead counsel has to be at the mandatory docket sounding. So they don't want an associate to show up. They want the person who's going to be trying this case, whoever that lead counsel is that's going to be trying this case, to show up at the docket sounding to tell the judge, we're ready to go. We're ready to go to trial, and we got the witnesses, etc. And the court is also saying, for docket sounding, you have to have a fully executed jury trial information statement, what the case is about, an index of the trial exhibits, proposed jury instructions, proposed verdict form, and the pretrial conference order. So this court is not messing around, right? They're telling, okay, here are the boundaries. Here's what everybody has to do. If you don't attend the pretrial conference, or if you're not excused, then it could result in dismissing the action, striking the pleadings, etc. And they're telling the parties they have to mark all the exhibits, blah, blah, blah. You can read this. And that once the trial date is set, which they've set it for August 2023, the court discourages any continuances, right? And the court, you can only continue this case, only continue the trial date past August if you get an order from the court, okay? So you can go ahead and read this. They're not going to be providing a court reporter. There's not going to be any recordings, not going to allow any video or audio recordings of the trial or the court proceeding, these pretrial conferences, docket sounding, etc. No one could take screenshots. You can go ahead and look at this. You can go ahead and read this. It was issued by Hunter Carroll, so Judge Carroll is going to be the one that's going to be moving this case forward or dismissing this case. We're going to see. It's his call to make. Okay, so I'm just completing through this so you can just take a look at it. Okay, that's it. Then we're going to look at the case management, which is interesting here. This is the case management order, which this is the third order the judge issued just recently. It is ordered this case management order supersedes any existing case management orders in this case. The court references the case management report, which I will show you next, which is very interesting. Filed on 4/13, the parties filed the completed case management report as they were required to do. They filed it on April 13th. The court is imposing all the deadlines that the parties agreed to in that case management report as court-imposed deadlines, and the court's going to hold everybody to those deadlines. Okay, when discovery closes, when you need to submit your exhibit list, when you need to tell us who your initial experts are, blah, blah, blah. And the court said the court will enter a separate trial order, which is what I just showed you. And it says that the experts required to provide written reports. What are they talking about, experts? They mean expert witnesses are required to provide written reports as well, as testifying later on, assuming this case goes to trial. So they have to provide a written report to the court. If it's a report from a doctor saying that Gabby's mom suffered, anxiety, depression, had to be put on medication, she had post-traumatic stress disorder, I don't know what they're going to say. But, maybe they'll say that about Gabby's father, but we'll see. Okay, but the court wants written reports from these experts. And the court says they're taking that case management, the initial case management conference that was scheduled, the next court date that we knew of, which was June 30th, coming up here June 30th. The court has taken that off calendar because the parties have, the court has already issued the trial order and the party has already completed the case management report. So the next thing the court's going to do is deal with the motion to dismiss. So the June 30th date for the initial case management conference is off calendar. They're not going to be holding that because the court is excusing that because the court has issued the trial order. Okay, and then the court is reminding the parties that you can modify the discovery deadlines in other words, when the depositions can happen, when they have to turn over phone records or whatever documents they want, either side to produce. That's discovery, right? That the court is saying the parties, you can modify the discovery deadlines, but you have to have, you can modify them without a court order, but they cannot extend past the discovery deadline, which is the pretrial conference, which it was July 7th, right? 2023. So they can do discovery up until July 7, 2023. I think I'm right about that. We'll see. Okay, and then anything else? The judge is reminding, Judge Carroll is reminding all the parties, the court will strictly enforce the deadline. They're not messing around here, right? We've got deadlines. Everyone needs to know about it. You need to abide by the deadlines. Okay, so now let's get to the very interesting thing that I think a lot of people have missed, the case management report. So here it is. Both parties filled this out with their counsel. It was filed last week on April 13th. And those are those questions that they had to answer. And if you look at my prior video, when I went over the case management report or the case management order, you'll see that this is what the court ordered the parties to fill out so the court would know, so Judge Carroll would know, do they want a jury trial? How long do they think the jury trial is going to be? Are there going to be experts? Blah, blah, blah. Okay, so here's what they filled out, and I'll show you what's interesting. So did the parties meet and confer? Yes, they did. This case management report is submitted on behalf of all the parties. All right. Then they also picked a jury trial. Jury trial, right? That's what the Gabby's parents want, is a jury trial. And it's to begin within 18 months. They gave the court the proposed trial date of August 14th. So the court looked at these dates and abided by these dates and set the trial for August 14, 2023. And they also picked the PTC, which is the pretrial conference, July 7th. The court adopted that date as well. The DS stands for docket sounding. They picked August 4th. The court adopted those dates too. All right. Estimated trial date. They gave 2 days. The judge in the trial order that I just showed you said 3 days. You know, that's fine. Including jury selection. That's interesting. They may go a little past the 3 days. We'll see. If it goes to trial now. So it might take them a little time to pick a jury with all of this publicity. Okay, you can go ahead and read that. Do the parties agree to the case management report? Yes. To the date of the lawsuit. Okay, here's where we get to the interesting stuff. Look at where I put the highlight. Do the parties believe a counterclaim, cross-claim, or third-party complaint may be filed? They answered yes. What does that mean to me as a lawyer? That means that a counterclaim is that Brian's parents could potentially be suing Gabby's parents for what? Possibly intentional infliction of emotional distress. What could they be arguing? All of those people that were outside their houses screaming at them? Maybe some statements that they are going to say that Gabby's parents made in the press? Maybe some, who knows? But maybe they're going to say that Gabby's parents caused them stress. Or they committed some negligence, or I don't know. But that's what a counterclaim means. You sue me, I may sue you. Cross-complaint, third-party complaint. Are there going to be other parties involved? Other parties being sued? I don't know. But a lot of people have missed this. To me, this indicates there might be another lawsuit filed. Possibly against Gabby's parents. Possibly. I don't know. But they didn't say no. They said yes. Have all counterclaims, third-party claims, and cross-claims been served? They answered no. No. Again, that shows me, I bet you there's another lawsuit coming down the pike here. Don't be surprised. All right, deadline to file a motion to add a party. Well, if they're going to add a party, if they're going to say someone else is responsible for the emotional distress that the Petitos suffered, that Gabby's parents suffered, you need to name them. Who is that person? By August 26, 2022. Then we get to the motion, deadline for all motions to dismiss directed at the pleadings. Now, Brian's parents have already filed the motion to dismiss, right? But they're saying now there's a deadline. There's another deadline. If you're going to file any other motions to dismiss or object to the pleading, you've got to do it by April 29th. That's coming up here real quick. 2 weeks. And look what else is interesting. Do the parties believe discovery will include substantial electronically stored information? I don't know. Is that text messages? Aren't they electronically stored? But they answered no. But maybe it's because the keyword is substantial. Maybe there's only a couple text messages. I don't know, but they answered no. That's interesting. Do the parties agree to exchange initial witness and exhibit lists? Yes. So both parties are going to be exchanging who their expert witnesses are. Who are they? Dr. So-and-so, therapist so-and-so. And their exhibit lists. Medical records could be exhibits. Photographs, text messages could be exhibits. They have to do that. It's the initial, not the final. It's the initial witness and exhibit list by May 20th. That's within a month from now, right? Do the parties anticipate having one or more expert witness? They put unknown. That's interesting. So they haven't figured out who their expert witnesses are yet. Okay, deadline to file expert witnesses. And again, this is next year, but these are dates, so you can look at this. To file expert witness list, this means who their final expert witnesses are. This is a year from now. So there's a lot that's going to be going on between now and then. One, does a motion to dismiss get granted? If it does, the lawsuit's over. Does a motion to dismiss get denied? The case proceeds to trial. And meanwhile, all the discovery, right? Depositions, sending interrogatories, written questions, requesting, parties to produce those text messages, whatever they're going to be asking. Okay, you can go ahead and read this. Do they agree to have the experts author written reports? Yes, and that's why the court ordered the expert witnesses have to provide written reports. You can go ahead and read all this. Experts that are going to author written reports to oppose or affirm claims. You can look at that. There's deadlines. These are all future deadlines. Adding a non-party. This is all next year. Okay, then what's interesting is the discovery deadline. That means you can't be asking any other questions, gathering any other information. You can't be asking for any depositions after. It says here, no discovery may occur after this date without the court's permission. So the discovery deadline cuts off next June. All right? That means you can't be doing any more discovery after June 2nd unless you get a court order. Okay, then they have a motion for summary judgment. So this is, a summary judgment motion is kind of the second opportunity that Brian's parents would have to get the case thrown out. If they lose on the motion to dismiss, right, the court does not grant the motion to dismiss, the case proceeds to discovery and then to trial. When the discovery is over, right, or during the time they're doing discovery, they can file a motion for summary judgment. They can say, yeah, Your Honor, we did all these depositions, we gathered all this information from Gabby's parents, and it's not enough to state a cause of action. So we're going to ask the court to summarily to issue a judgment throwing out this case because it doesn't state enough facts to allege a triable issue. All right? That's down the road now. This is next May. But it gives them a second opportunity to get the lawsuit thrown out before it goes to trial. Okay, then they're also telling us any deadline for other motions to be heard. Are there going to be any other motions? They have until next June to do that. And that, again, will be based on what they learn in discovery. Okay? Then we're also told that this case has a mediation, that these parties are going to get together with a mediator and try to settle this case. And the deadline for that is May 1st next year. Okay, so these are upcoming proceedings. The other thing that's interesting here is magistrate referral. I think it's the defendants, Brian's parents are objecting to this case being, I think it's Brian's parents, are objecting to this case being heard by a magistrate. No, I think it's the plaintiffs that objected. It doesn't matter. One of the parties objected to a magistrate hearing any of the matters in this case. In other words, they want Judge Carroll, They want the judge to be making the decision. Why? Because it's expediting the case and because they think it's substantial issues that need to be resolved by a judge, not by a magistrate. Typically magistrates, or in California, they're called commissioners. Those are the ones that are appointed by the judges to serve on, to hear certain hearings like small claims or discovery motions, that kind of stuff, to free up the judges to handle the trials and everything else, right? But because one of the parties objected to this case being heard, any of the matters being heard by a magistrate, the judge recognized that objection. In this case, all the matters regarding this case will only be heard by a judge. All right? So that's interesting. Okay, so you can go ahead and read this. This is all about the attorney's appearances, who's representing who, their contact information, because the court needs to know that. So just to scroll through, is there anything else? They served notice of all these orders to the respective parties. All right, so what's interesting is in that case management report that they file with the court is that there's a possibility of counterclaims, a possibility of other parties being brought into this case. It's very interesting. They didn't say no, they said yes. So I'm thinking, are Brian's parents going to be suing Gabby's parents? Or is there some other third party out there that's going to be suing one of these parties? So we're going to find out. But, the motion to dismiss is next. So that's probably, they got 20 days to fix their amended complaint. So they're going to be filing an amended complaint by May 3rd. Then there's probably going to be a motion to dismiss order. The judge will set a date for that hearing. That'll probably be sometime the end of May, my guess, early June. I'll keep you posted on that. Meanwhile, we're going to find out if there's going to be another lawsuit filed. And say, for instance, that it is Brian's parents suing Gabby's parents for intentional emotional distress. That case will more than likely be consolidated. And that if those cases go to trial, they'll have to prove both of those claims in that trial. It'll be a consolidated trial. Okay? I hope I made sense on that. So anyway, that's my analysis. Tell me what you think. Do you think there's going to be another lawsuit there coming up? Do you think that Brian's parents are going to be suing Gabby's parents? And for what? Intentional infliction of emotional distress? For negligence? I don't know. We don't know, right? But it looks like somebody's going to be added to this lawsuit. Possible another party, possible another lawsuit. So you let me know. Please do leave a comment. Please subscribe to this channel. Please hit that like button. Please hit the bell notification. Leave a comment. I want to know what your analysis is. And again, if you want to join my upcoming live streams, please subscribe to this channel. So, thank you very much for watching, and do subscribe.